Good evening and welcome to this, which is the second in a series of seminars that we're hosting in Chambers. And the topic tonight is employment status. And although I'm confident that there's a well-informed and knowledgeable audience, you're all familiar with the basics of employment status, the reason we chose it as a topic, it struck me that perhaps it isn't quite as straightforward as we all think it is, because it's managed to make 5 trips to the Supreme Court in 3 years, and that's probably more than any other topic that I can think of in employment law. When you're looking at these issues, whether you're advising clients or if you're sitting as an employment judge dealing with a case, what you often need is a structure, because in these cases you have a mound of facts. It's often very difficult to have a strategy for breaking them down into what's relevant and what's not relevant. And I think that the 3 questions that are addressed in Ready Mixed Concrete are a very good framework to start with. First limb is: the servant agrees in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. So it doesn't actually use the word mutual obligation, but I think it's imported by reference to the fact that it's talking about an agreement. The reason I want to say a little bit about mutuality of obligation is that it's a term of art that we all bandy about, but what I want to try and perhaps demonstrate briefly this evening is that it isn't always used in the same way by different judges in different cases. Sometimes it has one meaning, which I'll take you to, and other times it has another. And this just isn't just a semantic difference, it's actually a difference with some significance. The term mutuality of obligation should be confined to determining whether there is a contract at all, and not into determining the nature of the contract. And I said a moment ago that this isn't a sort of semantic, pedantic distinction that's been drawn, because the most recent Court of Appeal case that touches on mutuality of obligation is the well-known case of Quashie and Stringfellows Limited, which you will all have encountered. And in that case, the claimant was arguing that she had employment status both when she worked and when she didn't work. She argued there was an overarching umbrella contract. And the employment tribunal found against her. And they found that when she was actually working, that there was no contract of employment. And as you remember, that case went to the EAT. And the EAT said the tribunal had got it wrong, because they read the tribunal decision in respect of mutuality of obligation. They read the tribunal decision as holding that there was no mutuality of obligation at all when the claimant was actually working, which sounds counterintuitive, because there must have been some reason to determine why she was actually there. The topic of substitution clauses. So you will recollect that from the first strand of Mr. Justice McKenna's 3-limb test in Ready Mixed Concrete, the exchange of promises has to be for the employee to provide services personally. And one of the ways people over the years have sought to avoid employment status is to insert substitution clauses. And historically, we've always taken the view that if you can provide a substitute simply because you're unwilling to work, then there's no obligation to provide personal service and therefore no contract of employment. Whereas if you're merely unable, then there's an obligation to provide some service. He doesn't go along with that. He thinks that is something of an oversimplification. My view about it really has always been this, that if you have a substitution clause, there ought to be some economic or business reason for it, rather than simply having it in there. So, for example, if you have contracts that involve bank work, a bank of nurses, for example, it makes sense to have a substitution clause, because you know that there are a pool or a resource, a pool of people who you know are suitably qualified, and you don't really mind who turns up on a particular night so long as a particular shift is covered. Therefore, having a substitution clause makes sense. You don't need to tie a particular individual in to provide a particular service. If you have a long-term arrangement where somebody is recruited to work for you because of a particular skill, it makes no sense at all to have a substitution clause, because why would you want to have somebody else come along? If you have a long-term arrangement and you have a substitution clause, I think if it's to have any hope at all of being held to be anything other than a sham in the auto-cleanse sense, then there perhaps ought to be something in the contract that explains why you've got it there. What is the commercial reason for having it there in order that it makes some commercial sense?
Again, perhaps surprisingly, the Court of Appeal said, well, we accept that might broaden the scope of employment status under the Equality Act. It might mean that a solicitor or a plumber or a doctor being appointed might be able to bring a claim, and that's perhaps surprising and news to the rest of us. And the Supreme Court obviously had quite a degree of discomfort with that proposal. And they started off by saying, well, the appointment of an arbitrator isn't naturally described as employment at all. Applying a sort of know it when we see it test, an arbitrator doesn't seem to us to be an employee, even in the broad context of discrimination law. So looking to find support for that position, they turned to the European definition of worker under the well-known Allenby case. And the test under that for worker status was a worker is someone providing services for and under the direction of another person in return for remuneration. Someone who's not a worker, the contrasting position is somebody who's an independent provider of services who is not in a relationship of subordination. And from that, said the Supreme Court, the key concept is subordination. The dominant purpose test applied under the old law might be relevant to determining whether there's a relationship of subordination. On the other hand, it might not be the whole story. When precisely is the relationship of subordination? Well, said the Supreme Court, that's a broad question which will depend on the circumstances of the case. So that old chestnut perhaps not terribly helpful to us when we're looking to advise or litigate. No, said the AT, the judge got it right. Integration is one of the relevant circumstances of the case. That's what Jivraj tells us to look at. And on the contrary, the judge would have been wrong if they hadn't looked at the question of integration, because plainly it was a relevant circumstance. It would be necessary to go beyond those tests, go deep down into the evidence and see what can we find that points either in favour of subordination as a concept as a whole or against it. Another relevant case on subordination and a recent case is Halawi and World Duty Free. Now that case saw an attempt to argue that subordination is a concept that encompasses the notion of economic dependency as well as a kind of relationship of control. The general thrust of Section 41, which provides a principal must not discriminate against a contract worker. A principal is a person who makes work available for an individual who is A, employed by another person, and B, supplied by that other person in furtherance of a contract to which the principal is a party, whether or not that other person is a party to it and a contract worker is the individual supplied. So it could be that the end user has a contract with somebody else who subsequently contracts with the agency, who subsequently contracts with the individual. It might be more complex, in short, than the tripartite relationship. And that was certainly true on the facts of Halawi and World Duty Free, which you can see from my splendid diagram here. So the facts of this case were as follows. Mrs. Halawi worked in the World Duty Free counter in Heathrow Airport. She was selling cosmetics manufactured by the company called Shiseido, and she wore the Shiseido uniform. She was on the concession in the duty-free stand. She was using World Duty Free's tills, and she was subject to their to the rules they applied to all the concessionaries on their premises. So if you were rushing off on your holiday to somewhere sunny and warm from Heathrow, you passed through to buy some cosmetics from Mrs. Halawi, you might think, if you were thinking about those things on your way to your holiday, that she would be someone able to bring a claim under the Equality Act. She's somebody who works in a shop. She's plainly not there on her own account. We might presume, if we were thinking about these things, that she would be able to bring a claim. Not so, said the tribunal and said the EAT. It was necessary to go back and look at the web of arrangements under which she actually worked.
Partners, priests and politics. I start off with partners, and I stand here with some trepidation, being aware that for the most part you are employed by LLPs, or you are members of LLPs, and you probably know much more about LLPs than I do. Obviously, in relation to the Equality Act, there is express protection for members of LLPs, and indeed express protection for partners. So the position in relation to discrimination legislation is quite straightforward. Not so in relation to whether a person who is a member of an LLP should be considered to be an employee or a worker. So our starting point is the Limited Liability Partnership Act of 2000, and section 4.4 of that, which talks about members of LLPs shall not be regarded for any purposes employed by the limited partnership unless, if he and other partners were in a partnership, so that takes us back to the 1890 Partnership Act, he would be regarded for that purpose as being employed by the partnership. So it's an act which is designed to allow individuals to be both a member of the LLP and to be an employee, but to be taxed as partners. So we are aware that there are different types of partners within firms, and we had in 2012 the Tiffin and Lester Aldridge case. Martin Tiffin was a salaried partner to begin with, and was then admitted to the partnership as a fixed share partner. He had 5 profit share points. The full equity partners generally had about 200, between 100 and 200 equity share points. He signed a partnership agreement. When he was dismissed by reason of redundancy, he wanted to bring a claim for unfair dismissal and for a redundancy payment. It was held at EAT and Court of Appeal that he did not work under a contract for services, but he worked pursuant to the LLP membership agreement. So the leading judgment of the Court of Appeal is that of Lord Justice Rymer, who talked about section 4.4 of the Partnership Act, and said that unfortunately those who drafted section 4.4 of the Limited Liability Partnership Act was unaware that in law an individual cannot be an employee of himself, even if he is his hardest taskmaster. Nor can a partner in a partnership be an employee of that partnership, because equally it's not possible for an individual to be an employee of himself and of his co-partners. Really, I end with a reminder that this is not, as some would have us believe, a blank sheet of paper where 0 hours contracts are being used for the first ever time. We do have a body of case law, and we've seen fairly recently the G4S and Alfonso case, where a security guard actually requested to go on to a 0 hours contract for personal reasons.
Well, thank you all very much for your attendance this evening, and you're very, very welcome. We're delighted to see you upstairs for a glass of wine or anything else you'd like to have. So thank you all very much indeed. There you are, you win a bottle of champagne.